Hi, in this video we'll be talking about Article 3 of the EU's AI Act, Clause 6, which defines importer. Importer is a natural or legal person. So again, note that unlike previous, for example, provider and deployer's definition, it does not explicitly state public authority, agency or any other body. So importer has to be a natural or a legal person, that means an individual or a company, let's say, located or established in the union. So importer has to be located or established in the union, cannot be outside. That places on the market an AI system. So places on the market has a special meaning. We'll come to it when the places where these terms are defined. So places on the market means that AI is made available for the first time in the EU's market. So importer in that sense looks similar to a provider, but the difference is, if you see, it places on the market an AI system. Also note this, it is just talking about AI system and not general purpose AI model. So the definition explicitly excludes general purpose AI model from the definition of importers. So that's an important exclusion that we must look at the definition. So importer is a natural or legal person that has to be located in the union and that places on the market. Places on the market means this AI that we are being, that this AI system that we are talking about was not there in EU's market before. So importer is the entity that brings it to the European Union market. Again, note the difference, that it has to be an AI system and not a general purpose AI model. Now what? So that bears the name of the trademark of a natural or legal person established in a third country. Right? So first of all, it looks like provider but is not provider. Why? Because provider will either develop or get it developed. So a provider will develop an AI system or get it developed. Importer is not doing it. It is not developing anything. Rather, what it is doing is, the AI system bears the name of the trademark, name or trademark of a natural or legal person established in a third country. So let's switch on to this illustration again by my student Prapti Bhatt, who is a MS student at the Department of EECS at University of Tennessee, USA. Now, so let's talk about this here. So let's say the natural or legal person that we are talking about, which is established in third country, is, let's say, for an example, established in India. So once we have this, in this AI system is coming from this company and goes to EU market, right? Importer is the first person to place it on the EU market. Before that it was not there. Now note that it has to be an entity in a third country. It cannot be inside EU. So for example, if a natural or a legal person from Spain places on the market an AI system that bears the name or trademark of a natural or legal person established in France, that's not importer. That's something else. That something else is what we'll talk about in the next video. That becomes a distributor, but not importer. For importer, it is important to be established in the union, places on the EU market that AI system for the first time. Note the exclusion of GPAI. That bears the name or trademark of natural person or legal person established in a country outside European Union. That becomes an importer, and an importer is not a provider because It does not develop or get any AI developed. Now, before we conclude, the obligations of importer are provided in Article 23 of the EU's AI Act. We'll talk about those when we'll come to that article. And like a lot other entities that we have talked about in these videos, Article 25 marks those conditions where even an importer might become a provider. So one of the conditions is the moment importer puts its own trademark or name on the AI, now in that case it becomes a provider. So there's a very thin difference between all these entities, but they are all important. With this, I think we'll conclude the video. So if you have not yet subscribed to the channel, please do so, and please like, share the video. Thank you so much.